today?
Well, of course, I feel relieved. I want to thank the judge. It's very refreshing when you have a judge who sees things clearly and who's not worried to make the right decision. So I'm happy today. It's quite a simple case, but it has taken a lot of time, a lot of resources. So I hope we can try and move on. And I want to thank my lawyers as well. Mr. Valen worked very hard. I'm very and they worked very hard. And I think it's an interesting point that has developed in this case, which I hope will set the precedent for future cases under this Section 233, which they use all the time. You know, they use all the time against people they don't like. You know? People they like, they don't use, although offensive. So I just want to say that, you know, my speech was about change, about leadership, about what we need to do to get transformation for the country. It's not about offending anybody. I wasn't trying to offend anybody. I was trying to lift the spirit of the people of this country so that they can look forward to a better future. So instead of being, so I thought my speech was good, but they thought it was offensive. You know? But anyway, it's done.
Decision. Does it set any precedence? People being charged under 233. Does it set any precedence?
No, I think this is the first time they distinguish between the two limbs, 2331A and 2331B. So the decision just now was that under Section 2331A, the person who is annoyed has to be called to give evidence because the wording is another person. And then the second limb under Section 2331B, the terminology used is any person. So that's a general annoyance. But in this stage, they chose to charge Zaid under Section 2331A. So the judge said, well, actually, theoretically, then the specific person who was annoyed ought to have been called. But in this situation, they did call a variety of witnesses for the prosecution, but there was contradictory evidence. Most of the witnesses they called said they were not annoyed by the speech given. So I think that was the basis upon which the judge decided there was no prima facie case. So that's basically the basis of the decision, but I think the prosecution will probably appeal because this is a new issue that has been raised now, and perhaps if Zaid was charged under Limb B, then it may have been easier for the prosecution. Because the way I look at it, Limb A is confined to what I would call internet bullying on Facebook. So they're protecting individual persons who are being attacked. But Limb B seems to protect people from general blog sites and dissipation of articles that can cause general annoyance. So I think that's a distinction between the two limbs. But again, it will have to be taken up